focus my practice primarily in the trust and estates practice group. So we are going to be talking about the Secure Act tonight. Fairly new, fairly robust overhaul of the country's retirement system. Before we get started, we did have a number of questions submitted. And one person did ask, they're in a state that's not New York, and they wanted to know if the presentation was going to be applicable to them, and the answer to that is yes. So don't tune out. No matter what state you live in the country, the Secure Act does apply to you. It is a federal law now. We'll get into it. We'll start with a quick overview of the Secure Act. Stands for the Setting Every Community Up for Retirement Enhancement Act. It was signed into law on December 20th, 2019. It did pass the House of Representatives pretty easily. It had universal acclaim when it did come out. It was held up in the Senate a little bit in the late stages. Due to a lot of the what some senators believed was a negative impact on how they could collect taxes on the IRAs and other retirement accounts. But it did pass. The provision of the act did become effective January of 2020. Still was a lot of work to be done at the time. Obviously, the country's attention turned to the pandemic shortly thereafter, but the overall purpose of the act was to get more individuals on retirement plans. To do that, they try to incentivize saving more for retirement, and they also wanted to incentivize employers to offer these plans. So a lot of the provisions of the act do reduce administrative burden on employers and giving them tax benefits for offering these accounts. So the Secure Act does affect all types of retirement accounts, including 401ks. We're not going to get too much into the 401k provisions. We would be here all night if we did. So I thought many of the most interesting changes affected the IRAs. So it's going to be the primary focus of the presentation tonight, particularly in the estate planning context. Worth noting too, the Secure Act 2.0, this was just signed into law this past December. It was designed to build upon the 2019 Act. It did put a lot more benefits in place for employers and employees. Most of these provisions haven't taken effect yet. They won't take effect for another few years, 2025, just worth mentioning because it is in the news once again. Okay, so we'll talk about a couple of the IRA inheritance changes, and then at the end we'll get into some considerations you might have if you own one of these accounts or if you're a beneficiary of an IRA. But the first change we're going to talk about is the required minimum distribution age has increased. So prior to 2020, owners were required to withdraw funds from their IRA at age 70 and a half years. If it was a traditional IRA, they did have to pay income tax on it. Traditional IRAs are funded with pre-tax dollars. You don't pay any tax on the way in, you pay it on the way out. And the IRS does not want you to keep those accounts going indefinitely. They want to eventually collect some tax on you, so they do set a maximum age that you can go before you have to start taking distributions. So the Secure Act has increased the age to 72 years old. A year and a half might not seem like much, but it actually was the first time that they had increased that age since the 1980s. Starting this year, it will be increased to 73 years, and then by 2033 is planned to be 75 years old before you have to take the required distribution. The RMD, they're not applicable to Roth IRAs. Roth IRAs you fund with post-tax dollars because there's not really any more tax for the IRS to collect there, and they don't really care whether you take it and when you take it. The RMD rules currently at least only apply to the traditional IRAs, but it has increased, reflecting the fact that people are living longer, working longer, and very positive change all around, in my opinion. Okay, the next change, the age restriction on contributions has been lifted. So formerly account holders who were still working could not contribute to traditional IRAs after they turned 70.5 years old. Obviously the same age as the RMDs. That age, you had to start taking money out of the account, and you were no longer able to put money into it. Interestingly, the Secure Act did not increase the age; they repealed it altogether. So now, if you have an IRA and you are still working or have some other type of earned income, you can contribute to the traditional IRA or the Roth IRA, regardless of your age. The contribution age was never applicable to Roth IRAs, but they now are applicable to the traditional IRA. So any age, as long as you have earned income, you can continue to contribute. Earned income can be a variety of different things if you're employed or if you're getting rental income or any type of other earned income does account for this. Okay, the next change, penalty-free withdrawal. Typically, prior to 2020, you weren't able to take any money out of your IRA until you were at least 59.5 years old. So they did have a maximum age that you had to start taking money out of it, and they do have a minimum age that you can take money out. So if you took money out prior to that age, you were subject to a 10% penalty, no matter what type of IRA it was. If it was a traditional IRA, you had to pay income tax on the withdrawals as well. The Secure Act did create a new, you can withdraw $5,000 upon the birth or adoption of a child, and you are not subject to the 10% penalty. If it is a traditional IRA, you are still subject to the income tax. So again, another very positive change, in my opinion. It is your money. The 10% penalty usually incentivizes you to keep it in there, but if you do need it, if you have a child or adopt a child, that is available to you without any additional penalty. Okay, the next change is going to be the elimination of the stretch IRA. So as estate planners, this was the one that caught us the most off guard, and I find to be the most interesting of the changes. So prior to 2020, if you were a beneficiary of an IRA, you could choose to take the RMD based on your own life expectancy, depending on how old you were. This could be quite a bit of time. You could take the IRA in a lump sum payout, but you're usually left with a big tax bill. By taking RMDs over your lifetime, you can kind of stretch that out, sometimes over decades, depending on how old you were. This could help, reduce your tax burden. If you owned an account, this was beneficial as well. You probably didn't want as much of your money going back to the federal government in taxes. And this was one way to kind of reduce that burden. Plus, the rest of the money could continue to grow in the account in a tax-deferred state. And this was particularly beneficial for beneficiaries in their prime earning years. So age 40 to 50, you're still working, and if you inherited a big IRA and you were going to be pushed into a higher tax bracket, this could help you kind of reduce that. Taking the account over a long period of time instead. But the Secure Act, the IRS did not like the fact that they couldn't collect the tax for that long. So they now require beneficiaries to take full distribution of the account within 10 years of the account holder's death. This does apply to any account holder who died in the year 2020 or later. If they did pass away prior to that, the old rules are still in place. Beneficiaries can still take the distributions on a stretch basis. There is some exceptions to the rule. The Secure Act did create a new class of beneficiary called the eligible designated beneficiaries. This includes the account holder's surviving spouse, any minor child, any disabled or chronically ill individual, and any individual that was roughly the same age as the account holder. So they set the limit 10 years younger or less. If you left your IRA to any one of these four categories, the stretch IRA is still an option. I will point out that for minor children, it's not a full, their full lifetime. Basically the rule is as soon as they hit the age of majority, the 10-year clock starts at that time. I think it's a state by state basis. I think it's supposed to be 21. It may be 18 in some spots, what the age of majority is there. But it does kind of stretch out the amount of time that they can take the distributions for taxes. But generally, even for a minor child, it must still be fully withdrawn within 10 years of that reaching the age of majority. Interestingly, the RMDs are not currently required under the new rule. It's expected at some point. Proposed IRS regulations issued last year indicate that this could be required. But basically, the way it is right now, as long as you take it all out within the 10 years, it doesn't really matter how much you take per year, or even if you wait till the end and take it out all at once. But do expect that there's going to be some RMDs applied to that in the future. Whenever it ends up starting, right now expected to be sometime this year, maybe next year. It will be retroactively applied to 2020. This caused a little bit of a stir when they were released because a lot of people weren't aware of the act and maybe didn't pay the RMDs for 2021 or 2022, but the IRS did clarify that they would not be penalized for that. It's unclear at this point if they're still going to have to take catch-up withdrawals to make up for those 2 years, or possibly 3 if the IRS regulations don't go into effect until next year. But we shall wait and see. Okay, so account holders, what you need to be aware of, particularly when you're doing your estate planning. The elimination of the stretch IRA, the beneficiary choice becomes much more important, right? So the surviving spouse is going to be the obvious first choice. It is an eligible designated beneficiary. You have a lot of flexibility. The surviving spouse can kind of choose how they want to take possession of the account. They have the most options of any other type of beneficiary, and they aren't subject to the 10-year payout rule, so they can stretch it out over a period of time if they would like to, if that's beneficial for them. So that's usually the surviving spouse is the most obvious choice for your primary beneficiary on your IRA. Children, if you're leaving the IRA to any kids, minors and disabled children particularly, advise trusts. If they're not of age, they're not going to be able to inherit property outright. Setting up trusts for them in advance is beneficial. Disabled children, even if they're not minors, if they're adults, but they have a condition and they're on some type of government benefits, inheriting a bunch of money in an IRA. May cause them to lose their benefits or have some impact on it. So generally advise a trust set up for them to kind of diffuse that. You leave it to a middle-aged child. Keep in mind they're in their highest earning years. Kind of be aware of what they're expected to be making. You may not want them to inherit a big account that they're going to have to withdraw within 10 years. If that might push them into a higher tax bracket, it could mean more of that money is going to go back to the IRS. And trust as beneficiaries. I know we did have a lot of questions in advance about trusts related to this. So you can name a trust as the beneficiary of your IRA. The IRS does require it to be considered a see-through trust, which they define as being irrevocable upon the owner's death, valid under the law of the state that it was executed in. All beneficiaries must be identifiable. It seems pretty straightforward, but you look at trusts and not always can you tell who the actual beneficiaries are. And there are some filing requirements to the IRA plan custodian that you have to meet. So the 2 types of trusts that are going to qualify as see-through are going to be the conduit trust and an accumulation trust. Conduit trusts are fairly straightforward. The trust just acts as a conduit. The IRA plan is going to pay the distribution out to the trust, and then the trust is going to pay that distribution directly out to the beneficiary. And interestingly, if all the beneficiaries of the conduit trust are eligible designated beneficiaries, they get the benefit of taking the stretch IRA still. But all of the beneficiaries must be in that class, or it does not apply. And then the accumulation trust, the trustee just has the option to keep the distribution in trust, can let it grow, and do have a little more flexibility on how and when they pay it out to the beneficiary. So you can still name a trust as a beneficiary, and if it's see-through, then that's much preferred. You get a lot more benefit for doing that. As for the age and contribution changes, we think they're very positive for account holders. You have a lot more time to grow wealth, even if it's just a few years. Plus, you can continue to contribute at any age. Uh, but it does have the effect of encouraging you to retire later. If you can keep putting money into your IRA, if you work another couple of years and don't have to take your distributions yet, it may incentivize you to work a few extra years, and you're probably going to end up with a higher account balance. I know the last couple of years the IRA balances have not looked too good, but another couple of years, who knows? Things might go up. You may be in a much higher bracket than you thought. And I mentioned that for the estate tax exclusion. Not a lot of people are subject to estate taxes at this point. Right now, New York State does exempt your estate from tax at $6 million, 580,000. It's the 2023 limit. The federal government is 12,920,000, but the federal is set to decrease in 2026. Right now, they expect it to be about 5 to 6 million, right around the New York State. This could push a lot of people up into the past the exclusion amount. It might lead a lot more people to having to pay estate taxes. And I will note, estate tax is charged on your gross estate. A lot of people think if you name a beneficiary on your IRA and it passes outside of probate, that can also avoid estate taxes, and that's not the case. Both probate and non-probate assets are included for estate tax purposes. So if you're going to have a higher balance because of these changes, then may want to do some additional estate planning to account for the chance that you're going to have to pay estate taxes, or your state will when the time comes. And then the birth of a child, generally advise you to keep the funds in the IRA. It's there for a reason. It's meant to grow and save for a later date, but it could be beneficial to avoid large debt. Having a child, you're going to have a lot of medical bills. Could help new parents adjust to the higher expenses, child care and whatnot. As a new parent myself, I can tell you this is very expensive, and you may not be expecting how much it is going to cost you. Having $5,000 available to you from your IRA without a penalty could help out with those expenses. Plus, having a new child, you're probably going to need to do some additional estate planning. So you're going to have a lot of new expenses with the child, whether you have the child or you adopt. And it that 5,000 could go a long way. So it is beneficial, but I do kind of recommend you consult an attorney before you do that to see if it's in your best interest. Okay, then if you're a beneficiary of an IRA under the Secure Act, so it's going to depend on what class of beneficiary you're in. The surviving spouse has the most options. Again, the surviving spouse can take ownership of the account as their own. They can roll it into another account that they already own. They can take it as a lump sum. They can take it as a stretch. The surviving spouse has the most options for the account, and that it will probably go into their consulting with their own lawyer, how they will find it best to take it. Minor children, you can take the RMDs, you can have it set up through a trust. Highly recommend that the trust is set up for them. And again, the account does have to be paid out within 10 years of the child hitting the age of majority. Disabled or chronically ill beneficiary, you're going to want a supplemental needs trust, likely if you're on government benefits. You may be disqualified from whatever you have if you inherit too much money. And the supplemental needs trust can help spread that out over time and make it so it's not going to affect your benefits. Any individual 10 years younger or less, this is going to fall into the category of people that want to leave their IRA to siblings, cousins, partners, friends, neighbors, anyone that's roughly the same age as them. But the eligible designated beneficiaries, again, are not subject to the 10-year payout rule, and it can be stretched over their lifetime. Then the other class is the designated beneficiaries. This is going to be all other individuals. They're subject to the 10-year payout rule. Expect RMDs in the future. Right now, they're not in effect. You can take it at the end of the 10 years or at any point that you want, as long as it's fully done within the 10-year period. And then the last category is the non-designated beneficiaries. This is going to be non-individuals. If you make your own estate the beneficiary of your IRA, if you leave it to a trust, or if you name a charity as the beneficiary of your IRA, or any other non-individual. And those have different payout rules altogether, and it depends on whether the account holder was at the age where they had to start taking their required minimum distribution. If they are under that age, the account must be fully paid out to the non-designated beneficiary within 5 years. And if the owner's over the RMD age, they can take the payout over the owner's lifetime. So the IRS does have a table with the life expectancy that they calculate the RMDs based on however old the owner was. You would take the RMD payout over that time period. So, trusts technically are non-designated beneficiaries. Remember, see-through trusts are not applicable to this. They do pass through to the beneficiary as long as they are drafted properly. And then income taxes, this is going to be the biggest consideration. Remember, traditional IRAs, all the distributions are going to be taxable. The account holder did not pay any tax when that money went in, with the expectation that the tax would be paid when it is withdrawn. You will have to, the taxes will come out of there, when you get any of your distributions, if you are a beneficiary. The Roth IRA is not going to be taxable. That was, the tax was already paid on that money. It's not going to be taxable on the way out. Beneficiaries may receive an income tax reduction if estate taxes had to be paid. That is going to depend on whether what, if any, estate taxes were paid, but you may receive some type of income tax deduction if there were. Okay, so we do have time for some questions. I don't know if any more came in since we've been doing this. We did have a couple submitted in advance. Someone asked if any of the changes affected military inheritances. So as it stands right now, I'm not aware of any specific changes for military members. They're basically the same. One thing I will point out for military members, if you serve in a combat zone, typically your income is not going to be taxable. If it's not taxable, then it's probably more beneficial for you to put it in a Roth IRA. Again, if the traditional IRAs, typically you're putting in a pre-tax, so you're getting the tax deferred benefit from it. You're not going to get that if your income is already not taxable. So recommend that you do put that into a Roth IRA. The current contribution limit is $6,500, unless you're, I believe, over 55, then you can put in an extra $1,000. There's not any specific carve out for military members, making them eligible for any additional IRA benefits under the Secure Act, at least any new changes to be aware of. Looks like we did have a question for a Roth IRA. Is there a max income you earn that you cannot contribute to the to the Roth? There is, and let me pull that up. I don't have the number offhand. I believe it's somewhere in the $120,000 range if you are single. Well, I am looking that up. I will show one thing, since we talked about the required minimum distributions. There is a way you can tell what your distribution is going to be. I am hopefully it's showing up on the screen right now, but this is how you can calculate what the required minimum distribution is going to be. You're going to take the account balance as of December 31st of the last year, and then you're going to divide it by your life expectancy factor, which the IRS does have a table for determining this. It is actually listed a little bit lower here. So 72, you're going to see your life expectancy. You know, it's about 27 years. And as you go, you know, farther down, you know, you can see it is going down there. So this will be what's, you know, how your RMD is determined. That's a yearly value. Obviously, the more account you have and the younger you are, the more you're going to have to take. And right now, to answer the question, the Roth IRA is been increased as well, and that looks to be 153,000 for 2023. If you're single, if you're married, then it's going to be 228,000. After that point, you are maxed out. You can no longer contribute to the Roth IRA. Okay, and then back to the RMDs too. If you can see the screen here, if you are a beneficiary and you're in one of the eligible beneficiary categories and are going to take, you know, your RMD over different over your lifetime, here is the life expectancy and how you can calculate that with the younger years. So the IRS does have tables and worksheets for filling this all out, and that can all be done as far as the estate administration process when you're going through that. Okay, let me check if there's any other questions. Yeah, okay, so yeah, another question about if you inherit an IRA, are you required to take the RMD, or is the 10-year time still in place? So again, right now, there's no requirement of the RMDs. The IRS does plan to do that. It was a little bit of a surprise when that came out. It was not expected, but you know, basically, you know, the full account does have to be distributed within 10 years. Right now, you don't have to take RMDs. You can, you know, take it all at once. You can take it at the end of, you know, before the 10 years is up. You can take it yearly. You can take RMDs if you want to, but right now it is not a requirement. It will probably be in the future. Okay, we got another question. What are the benefits of a supplemental needs trust as a clause to a will? This is you know, specifically they want to create it for an elderly adult in a will. So it in a will, you know, supplemental needs trust acts kind of the same way. Whether the IRA is going to go into the will is dependent. Generally, the IRA, you're going to have a named beneficiary, which is going to be an individual or a trust or a charity or something. The only way it's going to pass through the will is if there's no named beneficiary on the IRA, or if you name your own estate as the beneficiary. And in that case, then your executor, you know, as part of probating your will have the supplemental needs trust set up for the beneficiary. The and you can choose how you want to take the distributions as a way to minimize the burden and the potential impact on the beneficiaries' government benefits. Okay, hopefully that answered all the questions. Did we have any more? Okay, I think that is going to be it. So unless anyone else has anything, we'll conclude the webinar tonight. Thank you all for being here. We're probably going to do if there's interest, we'll do another one. Updates on the Secure Act when the IRS regulations do go into effect, and we'll maybe touch on some of the 401k changes. But stay tuned for that. But have a good night, everyone. Thanks for being here. Bye-bye.